contrary to what the Supreme Court believed in both the Roe and Dobbs decision, the question of abortion has not been settled in the United States. The case of First Choice versus Davenport shows just how far some states will go to oppose the pro-life movement. We'll look at this next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. Glad you could join me today. Again, the question of abortion, the court thought it settled it back in 1973 with Roe v. Wade, only to, finally change their mind some 50 years later. But the decision's not settled. In the case of First Choice versus Davenport, originally First Choice versus Plotkin, Attorney General of New Jersey, shows just how far some government actors will go to get their way, to promote abortion. Now, if you want to follow the links, see all the details, well, head to the website, constitutionstudy.com. You'll find the article that's attached to this, and in there you'll find all the links to my quotes so you can follow along. I'll talk more about the website and ways you can support the work that we're doing here at the end of the episode. But for now, let's take a look at this case, First Choice versus Davenport. While the Supreme Court stated that the Constitution of the United States is silent on the question of abortion, that has not stopped some state officials from promoting an abortion agenda. This incident starts with a pro-life resource center, an activist attorney general, and a subpoena. Note, this case was filed against Matthew Plotkin as Attorney General of New Jersey. By the time the decision was released, though, a new Attorney General, Jennifer Davenport, was in office. First Choice Women's Resource Centers, Inc. is a religious nonprofit organization that has provided counseling and resources to pregnant women in New Jersey since 1985. Believing that life begins at conception and seeking to protect and honor life in all stages of development, the group does not provide abortions or refer clients to others for abortions. Seems simple enough. First Choice believes that life begins at conception and therefore neither provides nor refers clients for abortions. This apparently annoyed then New Jersey Attorney General Matthew Plotkin. In 2022, New Jersey's Attorney General Matthew Plotkin established a reproductive rights task force. Shortly after its creation, the strike force issued a consumer alert in which it accused groups like First Choice of seeking to prevent people from accessing comprehensive reproductive health care by providing false or misleading information about abortion. The alert concluded by directing women to abortion providers and asking members of the public who believed they were victims of fraudulent, deceptive, misleading, or unlawful conduct to please file a complaint with the New Jersey Division of Consumer Affairs. As I said, AG Plotkin apparently does not like pro-life centers, and high on that list was First Choice. Why else would he not only put out a consumer alert, but go searching for complaints against them? Now, if the AG actually had some basis for this action, like a single complaint against First Choice, well then, the search for others would be justified. However, not only had the AG's office not have a complaint against First Choice, their petition for complaints also came up empty. Neither that division nor the Attorney General's office received any complaints from the public about First Choice. Even so, the Attorney General served a subpoena on the group in 2023. The subpoena stated that it had been issued pursuant to several New Jersey laws, including the state's Consumer Fraud Act. The subpoena commanded First Choice to produce various documents within 30 days and warned the group twice that failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided by law. Now, apparently, not having a single complaint against First Choice did not deter AG Plotkin. His office issued a subpoena commanding First Choice to produce various documents, including the personally identifiable information about their donors and threatening legal penalties if they did not comply. In all, the Attorney General demanded production of 28 categories of documents, categories that themselves included as many as 29 subcategories. Most relevant for our purpose, the subpoena directed First Choice to disclose documents reflecting the names, phone numbers, addresses, and places of employment of all individuals who made donations to First Choice by any means other than through one specific web page. Effectively, that demand required First Choice to provide personal information about donors who gave through 2 other websites, through the group's various social media pages, by mail, in person, or by any other means. The subpoena sought documents about donations received over the span of multiple years, beginning from January 2021 and extending to the date of First Choice's response. Interesting. Without a single complaint, even after asking members of the public to come forward, A.G. Plotkin is still searching for a crime. In law enforcement, this is called fishing for a crime, or just fishing. Though the subpoena did not explain why the Attorney General sought First Choice's donor records, Mr. Plotkin later represented that his office hoped to contact a representative sample of donors to determine if they had been misled by First Choice about its mission and operations. In his view, First Choice's solicitation materials, including a donation webpage featuring pictures of parents holding infants and young children, could mislead donors into thinking First Choice provides abortion. A webpage featuring pictures of parents holding infants and young children could mislead donors into thinking First Choice provided abortions? That's just plain stupid. Because I think most people, when they see pictures of parents holding infants and young children, they don't think abortion. They're more likely to think pro-life. Now, to me, this doesn't sound like a fishing expedition, but an outright vendetta against First Choice. Now, First Choice responded to this outright attack on them with a federal lawsuit. 2 days before the deadline to produce documents, First Choice filed suit in federal district court seeking to prevent the Attorney General from enforcing his document demands. Shortly after that, the Attorney General responded with his own suit in state court. There, he accused First Choice of violating state law by failing to comply with his subpoena. Between the 2 suits, much litigation followed. So, First Choice sues in federal court, claiming the subpoena infringes on their rights. And the Attorney General sues in state court because, well, First Choice didn't comply with the subpoena. Who has the better case? A federal law, 14 U.S.C. Section 1983, authorizes suits against any person who, under color of state law, deprives another of his federal constitutional rights. First Choice filed a complaint under that statute, arguing, among other things, that the Attorney General's demand for information about its donors violated its First Amendment rights. While I agree that First Choice does have a case under 1983, it's not a First Amendment case. Why? Because the first 5 words of the First Amendment are, Congress shall make no law. A.G. Plotkin was not acting under the authority of a law passed by Congress, so his actions cannot violate the First Amendment. What they do is violate the Fourth Amendment because it is an unreasonable search and seizure of documents. As the Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. To me, this is not only a more straightforward argument, but on a better constitutional footing. Specifically, First Choice observed that the First Amendment prohibits the government from discouraging people from associating with others, in pursuant of many political, social, economic, educational, religious, and cultural ends. And First Choice alleged the Attorney General's subpoena had just that impermissible effect. For its donors, the group presented anonymity is of paramount importance, and its inability to guarantee that anonymity in the face of the Attorney General's demands injure the group by discouraging donors from associating with it. That's a pretty good argument, but not for the First Amendment. That argument shows a violation of Article 1, Section 18 of the New Jersey Constitution, which reads, the people have the right freely to assemble together. Now, First Choice did more than just file that lawsuit. In addition to its complaint, First Choice filed a motion seeking a preliminary injunction prohibiting the Attorney General from enforcing his subpoena. In support of its motion, First Choice tendered 2 declarations. In one, anonymous donors represented that if they had known information about their donation might be disclosed through an official hostile to pro-life organizations, each of them would have been less likely to donate to First Choice. The donors added that they submitted their declarations anonymously because they believed they might face retribution otherwise, given the Attorney General's record of hostility toward pro-life groups. In the second declaration, the groups executive director similarly represented that the Attorney General's request threatened to weaken First Choice's ability to recruit new donors, as prospective partners would be hesitant to risk the revelation of their personal information through government investigation. So at least some donors would have been less likely to donate if they knew their information would be passed out of the AG's office, based on his record of hostility to pro-life organizations. Again, a good argument, but for a violation of the New Jersey Constitution, not the First Amendment to the Constitution of the United States. This is not the first time the court has encountered this type of situation. Our more recent encounter with a demand for donor information came 5 years ago in AFP. There, California Attorney General Rob Bonta sent deficiency letters to the Americans for Prosperity Foundation and the Thomas More Law Center, the first a charity devoted to education and training about constitutionally limited government, the second a public interest law firm whose mission is to protect religious freedom, family values, and the sanctity of human life. In his letters, Mr. Bonta sought the names and addresses of anyone who donated more than $5,000 in a single year to either group. When the organizations protested that they kept their donor information private out of concern for their donors' anonymity, the Attorney General responded by threatening fines and the suspension of each organization's status as a tax-exempt charity. So California Attorney General Rob Bonta had already tried a similar tactic. It didn't work then, and it doesn't work now. The question in this case, though, is different than the AFP case, Justice Gorsuch referred to in his opinion. The First Choice case is about whether or not they could sue in federal court. Given the absence of any state court order compelling production, the district court reasoned First Choice had yet to suffer any injury from the subpoena and thus lacked Article III standing to challenge it in federal court. As I covered in my episode Unreasonable Searches, where I reviewed the oral arguments in this case, Attorney General Plotkin's argument that even though the subpoena compels the production of documents under threat of penalties, until a court orders compliance, First Choice was under no obligation to actually produce those documents. This is another ridiculous claim, but that was the basis of the district court's claim that First Choice didn't have standing to sue. The case before the court was not on the merits of First Choice's case or the actions of the Attorney General. Rather, it was a question of whether or not First Choice could legally sue at all. This case presents a narrow question. We are not asked to decide the merits of First Choice's federal lawsuit, only whether it may proceed. To have standing in a federal lawsuit, the plaintiff must have an injury in fact. The court seemed to agree that First Choice has, in fact, suffered an injury, just of the wrong rights. Against this backdrop, the question before us answers itself. First Choice has established a present injury to its First Amendment associational rights. Start with the Attorney General's subpoena. It told First Choice, you are hereby commanded to produce a variety of documents, including ones sufficient to identify donations made to First Choice by any means other than through one website. The subpoena defined the term identify as requiring First Choice to provide each donor's full name, present or last known address, phone number, and present or last known place of employment. Twice, the subpoena warned First Choice that failure to comply with the subpoena may render you liable for contempt of court and such other penalties as are provided by law. Having received a federal subpoena myself, I'm fully aware of the command that they claim to place upon a person or organization. Again, this is not a First Amendment violation, since it involved no law created by Congress, but an unreasonable search and seizure. The Attorney General's office was demanding detailed donor documentation without any probable cause other than his apparent animosity against pro-life causes. Now, that's not to say the AG didn't claim that First Choice suffered no injury, but that didn't convince the court. The Attorney General's three reasons why First Choice has not suffered an injury sufficient to maintain this lawsuit each fails. 1. It does not matter that subpoenas issued by the Attorney General are reportedly non-self-executing, such that any legal duty to produce records arises only when a state court agrees to enforce the subpoena. Now, whether the subpoena's demands and penalties are immediately enforceable or contingent on future court action, donors would reasonably fear disclosure and hesitate to associate, and a reasonable recipient of Attorney General's subpoena would be induced to trim its protected advocacy, knowing it stands in the government's crosshairs. This court's precedent does not impose and in fact foreclose a rule that would nonetheless require First Choice to await a state court order enforcing the subpoena before the group could challenge the Attorney General's demand in federal court. To me, this is the greatest failure and abuse of subpoenas. It deprives people of their liberty and or property without due process of law. It's one thing to compel attendance or the production of evidence in a court case, but to abuse subpoenas for investigative purposes is a flagrant violation of the Fourth Amendment. Second, it is of no moment that the subpoena allows First Choice to solicit funds through one specific website without disclosing the identity of those who donate through it. By restricting how First Choice may interact privately with its donors, the Attorney General's subpoena burdened the First Choice's associational rights, where the rule the government could channel the ability to disfavored groups to associate through narrow and state-preferred forms and achieve exactly what the First Amendment forbids. I think this claim of burden on associational rights is rather weak. Instead, what the court describes is an unreasonable search and seizure, along with a deprivation of the liberty to interact privately with their donors when there is no probable cause of a crime. Third, it makes no difference that a state court may soon, and with the Attorney General's assent, issue a protective order requiring the Attorney General to keep confidential any documents First Choice produces pursuant to the subpoena. Putting aside the uncertainties about any prospective protective order, demands for private donor information burden First Amendment rights, even if there is no disclosure to the general public. An official demand for private donor information is enough to discourage reasonable individuals from associating with a group and to discourage groups from expressing dissident views. So long as the demand remains outstanding, the pressure to avoid ties and speech that might displease officials demanding disclosure can be constant and heavy. Again, a weak argument. It also ignores the fact that A.G. Plotkin was searching for evidence of a crime he had no probable cause actually happened. That makes this an unreasonable search, and by demanding the production of documents, an unreasonable seizure as well. Finally, consider First Choice's two unrebutted declarations. In the first, several donors represented that each of us would have been less likely to donate to First Choice if we had known information about the donation might be disclosed to the Attorney General. The donors added that they submitted their declarations anonymously because they feared what they called the Attorney General's record of hostility toward pro-life groups. And this is more than enough to establish injury in fact under our precedent. To me, this shows probable cause that Attorney General Plotkin was not attempting to enforce New Jersey law, but using his position to enforce a vendetta against not only First Choice, but all pro-life organizations in New Jersey. Take each argument in turn, starting with the Attorney General's most ambitious submission. He says that subpoenas issued by his office are non-self-executing. Translated, that means they impose no obligation of their own. Instead, any legal duty to produce records arises only when a court agrees to enforce the subpoena. Categorically, he says, this means a recipient of a non-self-executing subpoena, like the one he issued in First Choice, suffers no injury unless and until a court enforces it. This conclusion does not follow from its premise. It commanded First Choice to produce private donor information, and it warned that a failure to comply may render the group liable for contempt of court or other penalties. The Attorney General's argument not only don't follow the premise, it doesn't follow logic or reason or even the English language. An order to compel with a threat of legal penalties is either a real threat or a false threat in an attempt to intimidate and extort. Neither is good for the Attorney General of New Jersey. Now, the first thing we need to remember is that this case is not about the merits of the First Choice case, only whether or not the case can proceed. Has First Choice been harmed by the threat? I would say an illegal threat made by the New Jersey Attorney General's office. Since the 1950s, this court has confronted one official demand after another like the Attorney General's. Over and again, we have held that those demands burden the exercise of First Amendment rights. Disputing none of these precedents but seeking ways around them, the Attorney General has offered a variety of arguments, some old, some are new, but none succeeds. Accordingly, the judgment of the Third Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. I would say the demands made by the Attorney General of New Jersey cannot burden the First Amendment, but they do burden the Fourth and Fifth Amendments. If the Attorney General had probable cause supported by oath or affirmation, he could have easily gotten a warrant to siege and search those records. He did not seek a warrant, I believe, because he had no probable cause. That makes this subpoena an illegal attempt to seize documents for an unreasonable search, depriving First Choice, the people who work there, and those who donate of their right to be secure from unreasonable searches. It also deprives First Choice and their donors the liberty to interact without unfounded threats of government enforcement. Now, I'm not sure how the Third Circuit will look at this case. From what I've seen so far, not only should First Choice receive their injunction against the Attorney General, I would like to see Mr. Plotkin's actions refer to the Department of Justice for criminal investigation. After all, he willfully subjected First Choice, their employees, volunteers, and donors to a deprivation of rights protected by the Constitution of the United States under color of law. Referring back to the oral arguments I covered in unreasonable searches, this is not a mistake or a misunderstanding. I believe there is ample evidence of Mr. Plotkin's true animus against First Choice and a deprivation of their rights, and no reasonable judge could allow qualified immunity for such a gross violation of the supreme law of the land. I don't know about you, but the actions of Attorney General Plotkin really piss me off. This is a criminal event. This is an abuse of power. This is a crime. It's a federal crime. Now, I hope that First Choice gets back to the Third Circuit and they say, yeah, we're wrong. This is a case, obviously, of overreach, of a deprivation of rights, a violation of the Fourth Amendment and the Fifth Amendment and the 14th Amendment. Will they? Who knows? I gave up trying to predict what courts do years ago. But it's important to understand First Choice recognized when their rights are being violated and stood up and did something about it. I'm glad they did, and I hope they get the outcome they deserve. And I really hope Mr. Plotkin gets the outcome he deserves. Not simply losing the case, but referable for criminal investigation. Because if a member of a state government can simply attack people without any cause, without any legal justification, just because he doesn't like them, well, then we're all in trouble. Rights don't mean anything if they can do that. That's why Mr. Plotkin needs to be punished for his criminal activity. What do you think? Do you agree with me? Do you think maybe there's a different point of view? Is there something you'd like to ask me about this case or others I've covered? Head to constitutionstudy.com/questions and ask your question. I love when people ask questions. I do ask for your name and email address because I'm going to email you a response, but I can also answer on my radio program if you check the box, Answer on America Out Loud Talk Radio. But I love answering questions. I think it's important for you. I think it's important for me. It's one of the ways you can help the work that we're doing here. Of course, you can also support us through the website, constitutionstudy.com/shop. Go to our store. That's where you can buy books and T-shirts and mugs or just donate to the cause. Nobody here takes a salary, so every penny you pay, every dollar profit we get goes to keeping the Constitution Study up and running. It also allows me to go do events in other locations without charging them for it. So please consider a donation. Again, constitutionstudy.com/shop. Of course, you can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They provide great service, 3G, 4G, and 5G service across the country, 100% US-based customer support, and really well-priced plans. And they take a portion of every dollar they make to support organizations like the Constitution Study that are defending your rights and helping you learn and study and defend your rights. Just go to patriotmobile.com/constitution, find a plan that works for you. See if you're eligible for a discount. Everyone from veterans and first responders to families with multiple lines can get a discount. And when you check out, use the code CONSTITUTION to get free activation. So defend your rights, the rights of your family and your neighbors with your cell phone by going to patriotmobile.com/constitution, finding a plan and discount that works for you. Don't forget that code CONSTITUTION at checkout to get your line activated absolutely free. Of course, I also hope you come back and join us the next time, maybe bring a friend or two when we get together for the Constitution Study.
Love your neighbors and have a few good friends.